My name is Scott Bandy. I'm with the Ada County Prosecutor's Office. I am one of the two chief criminal deputies in the office. We have two chief criminal deputies and one civil deputy. Jan Bennett is your elected prosecutor for Ada County. If you don't know that, she's responsible for all of Ada County, and I'll tell you, give you an idea of what our office does. As you see, we are split into two parts. We have a criminal division, which is the largest, and then we have a civil division. The civil division, they advise other county departments and answer legal questions for those departments. So we have civil attorneys that advise, say, waste management. They advise the commissioners. If weed and pest has a contract they need done, our civil division takes care of all of that. They also manage most of our human resources issues, anything that comes up that is non-criminal in the courthouse that involves a county agency, they will provide the advice. So the majority, as I said, is in the criminal division. Ada County Prosecutor, by statute, is charged with prosecuting all felonies. And so no matter where it occurs within Ada County boundaries, it comes to our office. Same thing with juvenile offenses. We get all of the juvenile offenses. We have a dedicated unit that just deals with juvenile offenders and juvenile crimes. Okay. There are a small category of what could be juvenile crimes that come to the downtown courthouse, but majority of those are traffic related. Inattentive, careless driving. There are some others like minor consumption that might come downtown, but each of those, the court has the option of removing it into juvenile court, depending on the person's age and other factors, not very common. But we do handle all of the juvenile offenses that occur in Ada County, and that includes real serious offenses. Batteries, aggravated batteries, what would be felonies or misdemeanors if committed by adults, we handle all of those. We are also tasked with doing all cases created by the Idaho State Police. And so no matter where in the county, it could even be within city limits. If it's an ISP officer, it's going to be our case. We do all misdemeanors that occur in unincorporated Ada County. That means outside of city limits. And then we also do misdemeanors for the smaller cities by contract. So we do Eagle City, Cuna, Star, and then we contract to do Garden City as well. So if you have a Garden City misdemeanor or one of those small city misdemeanors, it's going to say their name across the top. Garden City Police, Eagle City Police, we prosecute those. And so questions about those cases would come to us. So we are, because of the area kind of responsibility that we have, the number of cases, the types of cases, our responsibilities, we have created some efficiencies by having divisions within our office. Okay? We have a screening team. That's for both misdemeanors and felonies. We have a group of experienced attorneys who, when those cases come in, they screen them to make sure that, one, that a crime has been committed, and two, that it's the proper charge. So you may get arrested for or cited for a particular offense, but if our screening attorney says, I don't think we've got it, or it could be that crime, but it's better suited to be another crime, we will make those adjustments. And we do it prior to filing in most cases. That includes arrest. So you may get arrested for one offense and you show up for court the next day and it's something slightly different. That is done by our screening attorneys. Now, we used to have a preliminary hearing team, and what that meant was if you get charged with a felony, before it can ever get into district court and become a real felony, we had to go through a preliminary hearing. A judge has to hear actual evidence before it ever gets up there. We used to have a team that just did that. In collaborating with the public defenders over the last dozen years, we decided that that is not the best for our cases, not the best for the victims, and it's not the best for the defendants. They are better suited, and we are better suited to have a person looking at that case from the very beginning to make sure it's handled properly all the way through disposition. So while it used to be a standalone team, now that is merged into the next one, the trial teams. The trial teams in Ada County, we have a team that just does misdemeanors. So traffic court, DUIs, misdemeanor batteries, domestic batteries, that is handled by our magistrate division. And we use that as a starting point for our new attorneys. Regardless of how much experience they have, they start in our magistrate division so that they can get accustomed to the court process and learn how our system works, how our Ada County court system functions. And so those newer prosecutors are there. Sometimes we have laterals that come to us with experience, but they start there. The trial teams, they are assigned by judge. And this is another area where we've collaborated with the Public Defender's Office to try and align our teams so that we have the same public defenders working with the same prosecutors and the same judges. And you may think that's kind of strange, but what it does is it allows for a lot of efficiency for us. So when we get a case, I had spent some time with Danica back there on a team. The two of us, when we get a case, we know what our judge is going to do, how our judge is going to rule on certain motions. We have a pretty good idea of how they're going to sentence based on, a number of factors. So what we can do is we can quickly get to what are we actually arguing about. There are not too many what I call whodunits. There's not too many cases we're trying to prove that the person actually did it. Most times we are trying to figure out why they did it or present evidence why they did it and that there wasn't a justification for it. So when I get a case, I don't do a whole lot of trial work these days, but when I did, I would talk to the public defender and say, okay, where are we at? What do we need to work out? So the common misconception with criminal cases is that 90% plead because they have no alternative. They can't do anything other than that because they don't have adequate representation or there's not adequate time. That is not the case. And I hate that Danica's here because I'm going to say something nice about the public defenders. They are some of the most skilled attorneys in the state because they do the most cases. So when you hear in the community public pretender or any of the other disparaging names that people give them, that is absolutely not true. They have done these cases, they know their judges, they know how to do motion practice, and they do a great job. And I would say they make our job a lot easier because of that relationship. And we may get into court and we may, have real heated arguments on the record with the judge, but we can still come out in the hallway and be colleagues. We can be, not necessarily friends. I mean, I do have some friends in the public defender's office, but we can treat each other with respect. And we can talk about cases, and we can talk about issues. It's not a constant fight. So, in addition to our trial teams that are assigned all the general cases, aggravated batteries, felony DUIs, felony leaving the scenes, all the general felonies, we have a couple of specialized teams. And they're specialized because the types of cases require specialization. One of them is the domestic violence unit. Okay? Any of you are in the domestic violence arena, you know that there are things that are unique to domestic violence relationships. Number one, sometimes it's hard to get the jury of their peers to care because they think what happens between a man and a wife and a wife, husband and a husband, is their business. Well, we look at it differently. We look at it as there are some very uneven or unequal power dynamics in that relationship. Maybe one person makes the most money. Maybe one person is a citizen and the other isn't. Any number of reasons why one has the advantage over the other and may influence their desire to protect themselves. Okay? So our domestic violence unit is trained to deal with those types of cases, to recognize some of those things that may prevent a victim from keeping themselves safe or may prevent an offender from being held accountable. The other specialized unit is child abuse and sexual abuse. Anytime you're dealing with a victim of sexual abuse or a child victim, child witness, it takes not only some specialized training, but it also takes a certain personality. Okay. We only put people on those teams who want to be on those teams. They have to pick them. They have to be skilled at it. They have to be willing to go out and get the training it requires to recognize what's different about those cases. You know, how to talk to child witnesses. I mean, I talk to my kids, and now luckily the one's about to turn 18 and they're going to be out of the house soon. But I remember, you know, trying to talk to them, and they're both boys, and they're close in age, and it's, you know, I didn't do it, he did it, and trying to figure out how to communicate with those. That unit spends a lot of time in training and kind of developing those skills so that they can handle those. Like I said, we do all the juvenile cases, so we have a juvenile division. That's typically the second step in our career path. So you start in magistrate court and doing misdemeanors and traffic, and then you move to juvenile division. Those cases are tried to a judge. They don't get a jury trial there. Magistrate court with the misdemeanors, you get a trial if you want it, and it's 6 jurors. Juvenile court, it's back to a trial with the judge, and the judge makes all of the decisions about whether or not we've proven our case. Now, the reason we do that in juvenile court is juvenile justice is designed to rehabilitate the child, to figure out what we can do to help the child or the juvenile offender so that they don't come back. And so same thing with that group, our juvenile prosecutors spend some time learning how the juvenile justice system works, what the options are for helping the offender or rehabilitating the offender. Now, we also hold them accountable. We try to. But the focus is primarily on making sure they don't do it again. So again, those prosecutors, they're going to spend some time out there understanding the system. They do very complicated cases. Like I said, we get all juvenile offenses that are not auto waivers. They do very serious felonies out there. So they are learning how to do that. Sometimes our juvenile prosecutors become child abuse prosecutors because they really enjoy it and they really understand working with juvenile offenders and juvenile victims. And so that's kind of a natural transition. The next units we have are victim witness unit. I think Amy came and gave you a presentation earlier. We have an investigations unit. We've got 6 investigators that they don't do the initial investigation. That's law enforcement's function. But if we get a case where we need to fill in a few gaps, or we need to locate a witness, or we need to track down certain records to make our case better, we have investigators that do that for us. If you ever have contact with us and a victim witness corner, we might have an investigator in there just to be the person who takes notes and asks the right questions. We have a restitution unit. I think we have 7 people in our restitution unit. They do nothing but reach out to victims and try and figure out how to make them whole. In other words, if you're in a traffic crash, traffic accident, and somebody gets charged with it, we're going to try and get money to pay back for your car. If you have lost wages because of something somebody did to you, we're going to try and get that back. The big one is medical expenses and theft. If you have items stolen from you and they are not recovered, we will try and get the value of those items back for you. What restitution is not is like a civil case where you get pain and suffering or future losses, like future lost wages. So what it is it's designed to take care of actual out-of-pocket expenses that are a result of the defendant's conduct. So that unit, we collect in that unit in excess of $1.5 million every year in restitution just for victims. And so when we get it ordered, they track it, they enforce it. So we will do contempts, we will do probation violations to make sure that whoever did the crime makes the victim whole. We do have a pretty large support staff. We have 72 attorneys, and it takes quite a bit of support staff to keep all the documents flowing, and they're really the backbone of our office. Our legal assistants are usually 3 steps ahead of the attorney. They know what we need, they get it, they prepare it, and so that we can do our job. I explained the magistrate division. That's already that's our traffic and lower misdemeanors. So, how do things come to our office? Like Imelda from the TCA's office said, we generate the cases, the 99.99% of the criminal cases, but we don't do the investigation. That is law enforcement's function. And so if you have been contacted by law enforcement, if you have been a victim of a crime, we cannot do the initial investigation. That's not within our responsibility or our authority. That's the law enforcement's job. So even after law enforcement has done an investigation and we have you in our office, say as a victim, and you have due evidence, we are likely going to send you back to the original law enforcement agency, hopefully the detective or the officer that helped you the first time, and have them collect it. Because what we cannot be is witnesses in our own case. So I can't collect evidence from you and then turn around and present it in court because I'd be a witness. I'd have to ask myself questions. It would be awkward. So law enforcement does the investigation, and then they submit it to us, the prosecutor's office, for review. Just because law enforcement submits it to us does not mean we're going to file it. And anybody who's been in law enforcement for any amount of time knows that, not every incident, not every complaint warrants a criminal charge. And I will tell you, we decline a lot of cases. So the idea that if law enforcement shows up at your house, you're getting charged, that is not correct. We are going to do that analysis. Can we prove it? Can we prove it beyond reasonable doubt? Prosecutors have a particular ethical rule that applies only to prosecutors and not attorneys in general. We have to believe we can prove it at the time we file it. So we don't get to just file it and then hope we get enough facts later to prove it. I've heard more than a dozen times, well, that's the jury's job. Just throw it out there and see what sticks. Well, this is the protection that is built into our system that the prosecutor has to decide, before I even file this, I've got to have sufficient evidence to prove it. Now, I may be thinking, if the evidence comes out exactly like I want it to, we can prove it. But as long as I believe I can prove it, we can ethically file it. Okay? So, like I said, if you've had contact with law enforcement, if you have additional evidence, additional statements, those have to go to law enforcement first. Okay. On the flip side of that, the evidence has to come through the witness, the victim, or law enforcement. And so when we get to the point of having to present it in court, that's where it's got to come from too. I get the question all the time, can't you just rely on my written statement? Can't you just submit that to the jury? Well, one of the protections that I think is built into the system as well, and the TCA talked about it, is the system is designed to be fair. And so that means fair to everyone, including the defendants. So the defendants have to have the ability and they have the right to confront their witness. In other words, they have to have the ability to cross-examine or ask the witness questions about their testimony. And so there are certain stages of the process that we can submit written information, affidavits, but when we get before a judge or a jury, we have to present live testimony. Amy told you our victim witness coordinator, both agency and ADA PA, once it gets to our office, the majority of the cases, our in-house victim witness coordinators are going to be the victim's contact. So if you have an Ada County case and you want, and you're a victim or somebody working with a victim and need information, call our office. Even if it's not us, we can direct to the proper person. On our more serious cases, homicides, some sexual assaults, just serious cases in general, we're probably going to partner. We're probably going to have two. We'll have one from the agency so that they can answer the law enforcement agency type questions, and we're going to have one from our office that will handle coordination of court appearances and our part of the process. We try to assign a victim witness coordinator to all crimes of violence, and if need be, other offenses as needed. So we may get a theft case that we have a particularly vulnerable victim. We may assign a victim witness coordinator. If you're working with a victim of some other offense other than a crime of violence and you just feel like they would benefit from having somebody there to assist them, kind of keep them informed, we are willing to assign one to those types of cases. By Constitution, victims not only have a right to give input to the process, they can address the judge at sentencing. We ask them what their desires and wishes are for a case. On the flip side, they also have the right not to do that. So they have the right not to talk to anybody. They don't have to talk to me. They don't have to talk to defense. I mean, I can subpoena them and put them on the stand, but prior to that, they have the right not to talk. Oops. All right, what is going on with my case? That's the one thing that everyone wants to know, whether you're a defendant or a victim or even a witness. What's going on with the case that I'm involved in? When am I going to have to testify? What am I going to have to, how many times do I have to appear? We make every effort to try and keep you informed. Our handling attorneys in the magistrate division, their caseload's a little bit higher, so we may not be reaching out on a regular basis to tell you, okay, next week we're going to have a hearing where the defendant decides whether he wants an attorney. Those are things you don't really need to know. But if it's something of substance, like we're going to make a plea agreement or an offer, we should be contacting the victim. There are things we cannot tell you. That's for a number of reasons. There are certain things that, especially when it comes to your testimony, that we're not going to discuss ahead of time. We do not want to influence what you're going to say on the stand. So there are things that we're not going to talk to you about. There are things that we can't talk to you about because either you're not the right person, you're not the actual direct victim. Down there at the bottom where it says privacy applies to family members, it is very difficult when you have an adult victim or an adult witness and the family is involved, but the witness or the victim does not want them to know what's going on. Well, that is their right, that is their ability, and we are typically not going to reveal things that they don't want us to that are not part of the court process. And I think the PD will tell you the same thing. They're not going to talk to defendants' parents either. So there are certain things that we cannot tell you. If we cannot tell you, we will try and explain why. Whether it be court rule, the court has decided that the case is too sensitive for the information to get out. It's called a gag order. There may be certain rules of evidence that we can't talk to you. We may not tell you certain things just to preserve your testimony, but we will try and explain that to you. Again, court rules are meant to be fair, and they're fair to everyone. There will be limits on what we will tell you or can tell you if you are not the victim. If you are a witness and want to know things about the case, we are probably not going to tell you that. We don't tell those kinds of details to anyone that doesn't need to know them. Certain details we can't tell the victim either, but we will tell you that. All right, so again, they're divided into two levels. Misdemeanors are traditionally traffic, bar fights, batteries, but do include domestic batteries and DUIs and second DUIs. The maximum penalty on most of them is up to a year and up to a $1,000 fine. Each misdemeanor has a prescribed condition, but the main difference is misdemeanors you can only get jail, felonies you can get prison, and those two things are very different. Misdemeanors are that you get jail time. You may have a probation officer, but that probation officer is a sheriff's department employee. The maximum sentence you can ever get is jail. Felonies can be up to life in prison for the real serious offenses, and if you are released in the community after you've been found guilty or you've pled guilty, you will have a probation officer from the Department of Corrections, a probation or parole officer. The outcomes for felonies can be, again, up to life, and then there are fines associated with it. And certain felonies, the court can order a civil punishment to the defendant paid to the victim's family. It's up to $5,000. It's a very limited number of cases that you can get that. So, how do we get cases, and how do we decide to file them? Law enforcement submits cases to us in a couple different ways, 3 different ways really. We have arrest. I think you're all familiar with that. You get arrested on scene, you get taken to the jail, you get booked, fingerprinted, and you go before the judge, and the judge tells you why you're in jail. They can also cite you. That's most of your traffic offenses. Inattentive driving, all speeding tickets, the citation you get, the thing that speeding tickets, that's the same for up to the most serious of misdemeanors. They can cite you for that. The third way is what we call a write-in route, where the officer does the investigation, collects all the evidence that he thinks is relevant or possible to gather, and he submits it to us for review. Those are those cases where we spend a lot of time deciding, 1, has a crime been committed? Is it this person that's more than likely the one who did it, and should we file it? Okay. Not every crime gets filed. We have certain crimes that come in. A good example is theft, where it doesn't meet all the elements of the crime, like the intent to permanently deprive. Or it could be what we would consider better suited to go through the civil process, like eviction. Sometimes people will want us, they'll want us to charge people for trespass when they're actually a tenant and may have rights under the eviction codes. We may not file that. Could be a contract dispute. You paid somebody something to get a service or a good, and you're just dissatisfied with what they gave you or did for you. We're not going to charge those as crimes, but we could. So if we want to, if we've made that determination that we've got enough facts to go forward, that we believe we can prove it to a jury beyond a reasonable doubt, we may file it. And so when we file it, we take it to a judge and say, this is what we've got, this is our complaint, and the judge will say, yes, you've got probable cause, or no. If we've got probable cause, if the judge believes that this person committed a crime and it's more likely that it was them, they may issue a warrant. They can also issue a summons. A summons is a notice and a request to come to court, saying, hey, you've been charged with this offense, come to court and deal with it. That's not very common in felonies, because felonies by their nature are more serious. And there is a community safety risk to not getting them into custody quickly. Those are going to be, most likely, are going to be warrants. If you are arrested on a warrant, or if you come in on a summons, you will appear before the judge, and the judge will tell you, this is what you've been charged with, this is what the maximum penalties are, and ask you what you would like to do. They will also ask you at that first appearance, would you like an attorney? And if you cannot afford one will be appointed for you if that's what you choose to do. Now, in a large majority of misdemeanor cases, the prosecutor is also going to be there, and we will make a plea agreement, a plea offer at first appearance. Say, if this is there are certain misdemeanors that are not the crimes of the century, like, using your cell phone while driving, is that a misdemeanor? We may make an offer, a trespass. We may make an offer and say, hey, if you want to resolve this right now, this is what we're willing to do. You don't have to. That is completely optional, and the judge will tell you that as well. If we decline a case, in other words, if we get one of those cases that's routed to us with reports and evidence, and we decide we can't prove it beyond a reasonable doubt, we will decline it. And guess who we tell about declined cases? Nobody. Now, we're going to tell the victim that we declined to file a case on this, file a charge on this. But for the most part, we do not tell people that we have declined a case. And the number one reason is anybody can file a police report or complaint against anybody. But if it's not a crime, people don't have a right to know about it. I mean, the person who is alleged to have committed it, they've got a privacy right just like anybody else. And so if we decide a crime was not committed, the world does not need to know. So that's, we will decline it. Now, if it's declined because we don't have enough evidence, that may not be final. We have the ability to continue to collect evidence. A good example might be a cold case you hear about where we've got enough evidence where we think it's this person and they did it, but just not quite enough. We may wait. We may decline it and hold it open. Or another example is sexual assault cases. Sexual assault victims have the ability to come in and do an anonymous kit, just saying that they want it a kit done and recorded, and decide they don't want to be part of the system, don't want to be a victim at the time, but they may change their mind. And so that would be a type where we can resurrect it and say, yeah, we declined it because lack of evidence, but now we're going to file it. The only limit on that is what we call the statute of limitations. Most felonies are 5 years, so if we decline it but collect more evidence that makes it provable within 5 years, we can file it. Misdemeanors, it's 1 year. So if we've declined it and more than a year has passed, it's dead forever. Okay? All right, so misdemeanor cases, if you're arrested or we want a warrant, we have to show the judge probable cause. We will either file a complaint if it's one of those write-in routes, or we will file the cite with the court, the citation, and explain to the judge why you should be held in custody or be held on to answer after you post a bond. Most misdemeanors have a bond schedule, so if you do get arrested, there is an amount you can pay at the jail to get out. It's usually $300 to $1,000. But in either event, you will get the same process. You get a first appearance, and in each of these stages you can plead guilty. You're not obligated, you can plead not guilty. At each of these stages you get a first appearance where you're told why. You will get a pretrial where you have an opportunity to talk to the prosecutor directly, or your attorney will talk to the prosecutor and will try and resolve your case. We are going to offer a plea agreement at that time. We can offer plea agreements at any time during the process. If you do not want to take a plea agreement or you want your trial, you can have your trial. Every misdemeanor case, every case period can have your trial. You do not have to have a defense to have a trial. If you just want to put me to my burden and say, yeah, I maybe did it, but state, go ahead and prove it, that's your right as a defendant. Misdemeanors are 6 people, felonies are 12 people. You can waive that and have a trial just to the judge. It's not real common, but it's possible. You don't have to have a jury of your peers. You can have a court trial. If you think the judge is going to be more understanding to your case as a defendant, you can ask the judge to do it. So felony cases are a little bit, they have an added layer of protection for defendants, and there's an added layer of obligation for the state. Like I said, the only way a felony becomes a real felony in district court is a finding of probable cause. And that is done in one of 2 ways. A preliminary hearing, which is before a magistrate judge with no jurors, and we have to put on live evidence. So we can't put on those written statements. We can't put on the, your bank records. We have to have live people to come in and testify, say, this is what happened to me. If the judge says, yep, sounds like a crime was committed and that guy did it, he's going to bind it over and make it a real felony in district court. The other way to do that is grand jury. Grand jury is a proceeding that happens without defense counsel being there. Preliminary hearing, defense gets to ask questions. Grand jury is a proceeding that is only the prosecutor, but it's live jurors, it's not the judge. It's 12 to 16 people, and 12 of them have to agree to the same standards that the judge would. So it's kind of like a mini jury of your peers to determine whether or not this should really be a felony or not. Now, because the defense is not there, the state has the obligation to present all what we call mitigating evidence. That is anything that tends to negate the guilt of the defendant or could potentially mitigate the sentence or the charge down the road. And so if law enforcement responds to a domestic battery situation and the victim says, I ran into a cupboard door, or the defendant says, I was just defending myself, we have the obligation as the prosecution to present that at grand jury. And we let them decide. I mean, the good, the bad, 12 people have to agree that, yeah, this should be a real felony and go forward. If not, at grand jury, it's done. District Court arraignment is kind of like magistrate court. You get told why you're there. The judges at each step of the way advise the defendants of their rights. And again, if the offender wants to plead not guilty, they get their jury trial. We have a backlog right now. That's no secret to anybody. We're going to probably start trying cases at the end of this month again. But anybody who wants a trial can get a trial. We will give them their trial. So how does trial go? You may be called as a victim, you may be called as a witness, you may be called as a juror. But they all have kind of the same pattern to them. The first step is jury selection. Both sides are going to get to talk to the jurors and say are they a jury of the person's peers? And the strange thing about jurors is we're not picking who we want. We're trying to exclude the people we don't want. Every person is qualified to be a juror, but they may not be the best juror for a particular case. An example is if you've had a family member who's been a victim of a particular crime, you probably you're not a good juror to be on that same type of crime. Again, the system is designed to be fair to everyone. So the state wants a fair jury just like defense does, maybe for different reasons. We don't want it to be overturned on appeal. Defendant obviously wants a fair and impartial jury, but overall, we all want the same. We want a fair process that comes out to a just outcome. After you select a jury, each side gets to do their opening statements. We're going to present evidence. Again, it's live in-person testimony. It's sworn. You're on the witness stand in front of 12 people in a felony, in front of 12 jurors, and we're going to ask you questions, and hopefully you'll be able to answer. Once we get all of the evidence presented through witnesses, then the judge will instruct you what the law is. And the juror's main job is to hear the facts, and only the facts in the courtroom. You can't apply things you know from the newspaper. You can't apply things that you know from personal experience. You have to hear the facts, and then you plug them into the law. And the judge will say, if you find A, B, C, and D, find him guilty. If you don't find any of those, A, B, C, or D, find him not guilty. After he tells you what the law is, we give our closing arguments, try and tell you why you should convict or you should not convict. You go back and deliberate, and you come to a verdict. In criminal trials, it has to be unanimous, so all of the jurors have to agree. Some states it's not like that. Some states it's like 10-2. For us on felonies, it's 12-0. So all 12 have to agree that you're guilty, but all 12 also have to agree you're not guilty. If you get some mix in between, it could result in a mistrial. And that means the state would have the opportunity to try it again. Okay, I'm going to zoom through a couple of these. If you are found not guilty at trial, your case is forever closed. we can't retry you again for the same offense. It's called double jeopardy. Questions?
Test, test. All right, we're gonna come over for questions. The one thing I just wanna reiterate here is that if you're using a hypothetical, make sure it's not about any active cases. We need to be respectful of due process for anybody. So we just wanna make sure we're not asking questions that are really directly related to open cases in Ada County.
Because this topic came up so much throughout kind of the presentation, what is your typical response when you have victims who are crying or begging, pleading, please don't prosecute, my husband, or whatever that might be, but you have sufficient evidence to go forward? Like, what does that look like for you when you're discussing that?
So I will tell you that that is a very difficult situation, and it's not an easy call. We are going to err on the side of community safety. So in other words, there are certain offenses, there are certain facts that it is more important to protect the community, maybe from future victims. We're going to go forward. If we can prove the case, we're most likely going to go forward, unless there's something real serious that outweighs. If it's a kind of a borderline case, and we're afraid that if we get a not guilty, it's going to put the victim in more danger than to go forward, we may not go forward on that case. But that is a very interactive process. We try and attack some of the barriers to going forward rather than give up. Like if it is that where the victim is saying, if I lose him, I lose my housing, I lose my paycheck, I lose my ability to buy groceries, we're going to see if we can do something about that. If it is, as in a lot of domestic violence situations, I've been isolated, I don't have support, I don't have family, we may try and attack that. We may get them connected up with resources. I know that a lot of victims feel like this is the worst point in their life, and some of them it is, but oftentimes we have had those very same victims who are dead set against going forward and doing that very thing, telling us, my world is going to end if you make me do this, come back and say, I'm so glad you did it, because but for that, I would still be in that situation today. And so we're not callous, we're not immune to it. We're not, when we get a new attorney in our office we say, we don't count wins and losses, because if you're winning all your cases, you're trying the wrong cases, okay? We want to do what's right for the case. We want to do justice, we want the best outcome. Now, sometimes what that best outcome is hard to figure out. But if it comes to, what the victim wants or thinks is best for them right now, that's only going to be one factor. We're going to weigh future harm. We're going to, because I may not do something for this victim, but that may be the first victim of many, or maybe the third victim of many. And so those are the kind of factors that we weigh in. We fully respect the victim's opinion. We're going to give them input at every step, but ultimately it lies on the prosecutor to make the call. Does that answer the question? Kind of. It's a hard question, I know.
We have any other questions? Do we have anybody virtually? Okay, I'm going to give you guys a quick 5-minute break. But thank you so much for your time. I think after lunch we need to walk around a little bit. So thank you.